All right. Whew, one moment. Welcome to today's celebration of Lysander Spooner's birthday, January 19th. With me today, I'm Kirsten Tynan, Executive Director of the Fully Informed Jury Association. And with me today, we have Robert Anthony Peters, FIJA's Board President, and Dr. Nathan Goodman, FIJA's Board Secretary. Welcome, guys.
Thank
you
you
so much for having us.
All right. Just to get started, maybe we'll go. I didn't prep you for this, so let me know if you don't want to answer it. But how did you first learn about Spooner? I guess I have in my mind thoughts on which Spooner door people came in, and in the jury world, I assume everyone read his essay on the trial by jury, and that's not always the case, as I found out last year. So what Spooner door did you come in? And then we'll get into a little bit about who Spooner was and why he's important to jury rights and what he had to say about them.
I think in my case, I first encountered Spooner because a lot of libertarians and individualist anarchists and so on social media would quote from The Constitution of No Authority, in which he argues that because the United States Constitution was essentially an agreement among a small group, a group that is from one specific generation, that it doesn't legitimate or justify the state in itself or bind future citizens to obedience to the United States government. It just binds those who take actual oaths to it. And he also, of course, is referencing this in a context of opposing a variety of coercive and authoritarian actions by the United States government, including the context of his own abolitionism and opposition to what the government does to, for instance, enforce fugitive slave laws. And so he there said, the quote that I think I saw plastered all over people's Facebook pages was, "But whether the Constitution really be one thing or another, this much is certain, that it has either authorized such government as we have had or has been powerless to prevent it. In either case, it is unfit to exist." So that was my initial exposure to Spooner, was seeing that quote everywhere on social media when I was in high school and getting into libertarian and anarchist circles.
Interesting, Robert.
Certainly the first reading would have been as well The Constitution of No Authority. That would have been the first Spooner that I had read. And it's just a lovely intro to kind of the anarchism of the individualist side. I think my first encounter was likely due to Randy Barnett's work on him. I had when I was at the University of Arizona, the Federalist Society here held a talk with Randy Barnett as the speaker, and then listening to him speak about Spooner. And then he's got a pretty comprehensive, I believe it's still online, lysanderspooner.org. Yeah, very comprehensive website where there's a ton, kind of anything you want to learn, or it's kind of a clearinghouse for Lysander Spooner fans and knowledge. So just intrigued, and just there was the reading of Constitution of No Authority, but just learning about the man's life. He's just a fascinating guy. He kind of had his hands in a lot of different pies and was very, very thorough, very principled, very active, very engaged with his times and with the ideas that he was interested in. And I still hold, there's a lot of people that the more you explore, the more you're like, well, I don't know if I like this guy or not by the time you get to the end of the rabbit hole. But he's one of these guys where I'm just like, I every time I learn more about him, I tend to like him more. So I haven't found things that I don't like about him yet.
I have one thing I dislike about him, but that's just the one. And since it's on his birthday, I may not mention it unless you want to go into it. It's not like a big deal. Also, it's that he was very strongly pro-intellectual property, and I am not.
Yeah, that's fair.
Okay.
That's fair.
Okay.
I will concede that as well. But in some of these things, it's just it seems like it wasn't quite the time to have certain realizations, right?
Mhm.
You know,
Yeah.
as a man of his time, he was extraordinary.
Oh, yeah.
Yeah,
And the
yeah,
other thing is, even that disagreement is one where he held that position and he held it in a very extreme way because he thought that it was an individual right of the creator. So it was still him seeking out the logical implications of a theory of individual rights. He just happened to take it in a direction that I personally disagree with. But even that is very consistent with his character as a very principled person who believed deeply in the human rights of every individual and sought to elucidate what those were and then apply that consistently. And that's what got him to so many good conclusions on so many important issues, especially the most pressing issues of his time, such as the abolition of slavery, where he was a staunch abolitionist. And so I think that even
and
his
jury
errors,
rights were tied into that strongly.
absolutely, yeah.
Yeah.
and it does seem to me like that's one of those areas where, despite maybe Stefan Kinsella might argue with me, but I feel like reasonable people could hold disagreement on it. You know,
Mhm.
I agree with you on that and disagree with Spooner.
Well,
But it's also one of those things. I don't know that that's the hill I want to die on. Abolition
yeah.
of slavery, that seems like a much,
Yeah,
consistency on that is,
absolutely.
much more significant.
And okay, so we've talked about his character. What about in practice? What was he like in practice, and what things did he do in his life that maybe had something to do with jury rights?
Well, one of the most famous, of course, pertains to setting up the American Letter Mail Company, a competitor to the post office, and directly challenging the prohibition um, on sending first-class mail through any entity other than the post office. So that's a direct challenge to state monopoly privileges and relates to his broader view that things that aren't a violation of the rights of others are not a legitimate purview for governmental coercion. And so that would be one reason he would care about jury rights, is as a protection of individual rights. But of course, the biggest thing, and you and Robert could talk about this more, and we've alluded to it already, was his staunch involvement in the abolitionist movement. He was firmly opposed to slavery and to the enslavement of African Americans in the US in particular, but to slavery in general. And as a result, he would be very interested in the rights of juries to do things like nullify enforcement of the Fugitive Slave Act, for instance.
And he was an attorney too, wasn't he, Robert?
Yeah. Oh, absolutely. Absolutely. I do want to go back, because since I do have a shipping company, I do have particular fascination with the American Letter Mail Company. And just the fact that, I mean, it was such a challenge, and he wasn't really the only person challenging the post office at that time, but he was one of the most significant, and he forced, actually, I believe it was the only reduction in postal price in history, that the post office had to reduce their price for first class mail. They'll do temporary surcharges that expire, and so sometimes we'll see the price go down, but it is not a price reduction. It was just the removal of a temporary increase. Yeah. So there was that, and this was something I learned recently, that he compelled the post office to basically deliver to a residence, specifically to a house, which they weren't doing prior to that. So,
wow,
fascinating.
So the fact that we get mail at our house, in most places.
Yeah, well, and it's funny because as time has gone on, now you see there is a larger push for mail to be more centralized for communities. You have community mailboxes and things like that. And there's a big push actually from the house to the street too. If you ever change the location of where you get your mail, like from your front door flap, and you put it on the street, you can never go back. Yeah.
When I lived in Phillipsburg, Montana, I didn't even get mail at my house. We had to go down to the post office. You got a free PO box, but I'll say free in quotes, as free as it is. Yeah. But you had to go down there. They wouldn't drive up to my house. If I wanted my mail in the winter, I had to go 3 blocks downhill on an icy street to go fetch it.
Well, and it's interesting because, one could say, okay, maybe if you lived remotely, it's 5 hours on a dirt road, to get the mail there. Okay, you could make a case. But you lived like there were
3 blocks.
Yeah, I mean,
on a paved road.
I
Yeah.
felt that that was not reasonable for them to not deliver it to your
Yeah.
house in that location.
All right. Now to Spooner as a lawyer. He had some interesting an interesting background as a lawyer, because at the time that he was becoming an attorney, law school wasn't the main way to go, and it was kind of a new way to become an attorney. Does anyone want to talk a little bit about how he became an attorney?
Well, I do know he kind of was encouraged to hanging his own shingle in violation of the law at that time. I guess it's like his apprenticeship period had not ended by then, and so he kind of jumped the gun, and he argued, listen, this is a violation of private contract. People should be allowed to work with me if they want to, and then also kind of talking about these restrictions as really being anti-poverty, right? Or anti, making life more difficult on poor people because they have fewer options, and hey, like in most fields, most of the time when you're starting out, you do things at a reduced rate. You can hire the services of somebody who's newer, usually cheaper than a veteran, somebody with a tremendous amount of experience whose time is arguably, at least according to the market and people's perceptions, is worth far more. So he was arguing, listen, part of this is you're excluding poor people from participating in as good a way as they can, and also, just this ability to contract for my services. Why should you do that? And Massachusetts overturned that. They actually revised that.
Yeah. I mean, it's important to emphasize that part of it was the apprenticeship term that he was required to have was longer because he didn't have a college degree. And so college graduates were allowed to study with an attorney for 3 years and then strike out on their own, whereas Spooner, as a non-graduate, was required to study with them for 5 years before going out on his own to offer legal services. And so that distinction he regarded as discrimination against the poor. And so we see an effect both on the producer side of restricting economic opportunities, restricting people's ability to offer their services to willing buyers. And because a market exchange naturally happens between two people, a buyer and a seller, it's also a restriction on the rights of willing buyers. And by creating a state-protected cartel or monopoly through a barrier to entry, in expectation, these licensing laws increase the price of legal services, which are an especially important thing to be worried about people being priced out of access to, because that's, part of the business of rights protection, both in the protection from the state, in the case of, for instance, criminal trials, but also protection from your fellow citizens if your rights are violated by a tortfeasor and you have the desire to pursue a tort claim against them.
All right. Did you just say tortfeasor?
Yes.
All right. I know if I'm going to need some help with that term, I'm not the only one who's going to need some help with that term.
The basic idea here is somebody who commits a tort that is a wrong against another, for which they're thereby liable. So, for instance, if I hit your car and you wish to sue me, now of course we have insurance markets that cover this, which means that rarely comes to litigation. But if I do some other harm for you, like say I sell you a loaf of bread and I haven't disclosed that there was some unusual additive in it that was dangerous to you, or that I adulterated it with something, and you get sick, I may have committed a tort against you. You have the right to sue me because I've done something for which I'm liable. And we could think of this for any number of things, whether that's spilling stuff on your land or vandalizing, right? Like tort law is essentially just, whereas criminal law situates the state as acting as a representative of the people prosecuting an individual, tort law is about relations between people where one has wronged another. And so that's what we usually think of lawsuits as regarding.
Okay. So the tort is a wrong that someone does, someone else.
Mm-hmm. Yeah.
And a tortfeasor is?
Basically the person who committed the tort.
Okay. Got it. So, yeah. Okay. I'm following you.
Yeah.
Okay. Now, I was just trying to do double duty here. I wanted to get a little bit into what Spooner's first work on jury rights is, and I'm not entirely sure of that. So far, the ones that I sort of have on my timeline are Illegality of the Trial of John W. Webster, which he published in 1850, an essay on trial by jury, which was published in 1852. And those are the two primary ones that kind of go with the abolition era, the Fugitive Slave Act having been passed in 1850. And then I have Vices Are Not Crimes, a Vindication of Moral Liberty, which wasn't published till 1875. I found that kind of interesting because it was actually not tied to slavery, but to alcohol prohibition. But I believe that an essay on the trial by jury was actually an appendix to one of his other works. I thought it was something about the Constitution of No Authority or his work on slavery, but those appear to be in 1860 and 1870. So I'm not 100% sure on that. But let's get started talking a little bit about how jury rights and his views on jury rights were tied into his views on slavery. Does anyone want to give some opening comments on that?
I think the unconstitutionality of slavery was earlier than that. I think it was in the 1840s.
Okay.
Yeah.
That would make much more sense because I thought it was an appendix to that he then expanded into at later work. But just quickly Googling, I saw 1860. I was like, that doesn't make sense. Okay. Yeah. Possibly multitasking is not serving me well today.
I think, I guess there's many ways to look at a life, right? But in some ways, there's kind of a dichotomy or a shift, one might say, between the unconstitutionality of slavery and his trial by jury, where you kind of he's kind of making legal professional arguments, maybe we can say, about abolition. And abolition seems to.
So that would be like when you say legal professional arguments, like what works to get the job done. Is that kind of what you're getting at there? Or?
I guess what I'm thinking is like making a case to lawyers, to judges, to statesmen of, hey, this is why we should not have this institution. This is why this is a bad idea. And it seems as though he kind of ran that course to the best of his ability, and I think did an admirable job, but realized he wasn't getting the results he wanted. And then trial by jury was almost his plea to the common man, hey, now it's your turn. We need to rely on you to take up the mantle and to solve this problem. I feel like abolitionism was his driving force. And of course, when you define it broadly enough, right, that encompasses the totality of the anarchist mission, abolition of slavery of any individual to any entity. And so I think, it does make sense. I mean, I know anarchists, right, who refer to themselves as abolitionists. And so, just viewing it a different slave and master category, as opposed to, mere I don't mean mere as in, but to
unimportant, yeah,
not
unimportant.
Only chattel slavery, there could be considered many types of slavery. It seems like there was the reformer Lysander Spooner, and then the revolutionary Lysander Spooner, and I think the trial by jury, that's kind of his departure from the reformer more into the revolutionary, where he believes, liberty, must be presumed and must be taken. And, we've got to kind of, that these trial is not to determine government's power. I'm paraphrasing him, over people, but people's liberties against government.
I think all of that's right. I also think that, in particular, the enforcement of the Fugitive Slave Act and his belief in the use of jury nullification as a rightful remedy for the unjust enforcement of that law was part of his motivation in supporting in working on the issues of trial by jury and supporting the right of juries to engage in nullification of laws that they believe to be unjust. And he's quite explicit about this. So if I may quote from an essay on the trial by jury, he writes, quote, the bounds set to the power of government by the trial by jury, as will hereafter be shown, are these: that the government shall never touch the property, person, or natural or civil rights of an individual against his consent, except for the purpose of bringing them before a jury for trial, unless in pursuance and execution of a judgment or decree rendered by a jury in each individual case upon such evidence and such law as are satisfactory to their own understandings and consciences, irrespective of all legislation of the government. And then he quotes a thing that he might think would be asked in, say, the voir dire process, right, the jury selection process, quote, do you hold any opinions upon the subject of the fugitive slave law, so-called, which will induce you to refuse to convict a person indicted under it if the facts set forth in the indictment and constituting the offense are proved against him, and the court direct you that the law is unconstitutional? The reason of this question was that the fugitive slave law, so-called, was so obnoxious to a large portion of the people as to render a conviction under it hopeless if the jurors were taken indiscriminately from among the people. And so he's recognizing that many among the population share his moral convictions against the Fugitive Slave Act, and that prosecutors and judges try to avoid the inconvenience that that causes to their enforcement of the fugitive slave laws via weeding out jurors who might conscientiously acquit or engage in jury nullification.
So interesting how that parallels how things work today, with questions about what people think about different laws, what people think about the police, who are frequently witnesses in certain cases, and that sort of thing. It also kind of strikes me that one thing that I have had some people sort of argue is that jury nullification, you're only allowed to, or should, neither of these are true, so I'll use both words to reflect what is kind of brought to me, but you can only nullify in cases where a law is unconstitutional. And I was like, no, I don't think so. And like reading through Spooner, I think he would probably agree with me. One thing he also sort of differentiates in trial by jury is a trial by the government versus a trial by the country. And I think that kind of goes along too with what Robert was saying about how he was appealing to his fellow people to kind of take these laws apart. Spooner, of course, would have said that slavery was not constitutional. But I think regardless of where you came down on that debate, he was asking you to nullify and to provide a trial by the country, not by the government. Does someone want to talk a little bit more about what the difference between those two things might be?
Yeah, so he's very explicit when he writes, a jury that is palpably nothing but a mere, he lays out a context in which he says various questions, the question about the Fugitive Slave Act that he mentioned, as well as questions that were asked to Massachusetts jurors about whether they had conscientious scruples against finding people guilty in capital cases where they know that people would be punished by death for their crimes. He said that the principle on which these are asked is, quote, that no man shall be allowed to serve as juror unless he be ready to enforce any enactment of the government, however cruel or tyrannical it may be. And he says that such a jury, quote, is palpably nothing but a mere tool of oppression in the hands of the government. A trial by such a jury is really a trial by the government itself and not a trial by the country, because it is a trial only by men specially selected by the government for their readiness to enforce its own tyrannical measures, right? So the idea of a jury of your peers, in Spooner's view, is it's supposed to be kind of a random cross-section of the community with perhaps a diversity of views, who can then, on the basis of their consciences, act as a check against the power of the government, and can be presented the evidence pertaining to the case and evaluate it given their own knowledge of both what the facts are and what is just, right? By contrast, if you exclude from the jury pool everybody who holds any scruples about the exercise of state coercion, all those who might judge not just on whether you whether the government has made their case when it comes to the facts in the law as they tell the jury the law is, right? And Spooner also elaborates elsewhere in the essay about how, well, if they can dictate what the jury must find given a set of facts, they can also dictate the rules of evidence. And so if you exclude the possibility of jury nullification, you're also limiting their ability to act as fact finders and evaluators of evidence related to the facts of the case as well. But the point here is that the government is kind of rigging their hand. They're engaging in something analogous to gerrymandering, right? So if you define district boundaries when it comes to an election in a particular way, you can select for a particular subsection of the population being the voters. And in this case, the government is similarly trying to select a particular subset of the population as jurors, particularly those who have the most fealty to the government and the least scruples about whether or not to permit government coercion.
And I'm flipping between screens here just to make sure of okay, it doesn't look like Robert's chomping at the bit to say something, so I'm going to throw in something that's kind of related. Okay. Just to divert a little bit, he makes much it's not just abolition that he's applying these thoughts to, and as some evidence of that, so Trial by Jury was written in 1852. In 1850, he wrote The Illegality of the Trial of John W. Webster, which was a death penalty case. And in that case, he talked about trial by the country. I'll quote here and then kind of talk a little bit about what it means. Quote, "The trial by jury is a trial by the country in contradistinction to a trial by the government. The jurors are drawn by lot from the mass of the people for the very purpose of having all classes of minds and feelings that prevail among the people at large represented in the jury. They are drawn by lot from the mass of the people for the very purpose of making the jury a fair epitome, mentally and morally, of the country, that is, the whole country. A tribunal thus selected is supposed to be a more just, impartial, and competent tribunal than the government itself or any department of it would be, and unanimity on the part of the members of this tribunal is required in order that no man may be punished or condemned unless the whole country, so far as that is supposed to be fairly represented by the jury, shall concur in the conviction and punishment. This concurrence of the whole country as condition of conviction and punishment is required from motives of both justice and caution towards the life, liberty, property, and character of the person accused. It is supposed that if any portion of the country, as represented in the jury, dissent from the conviction or punishment, that dissent gives sufficient reason at least to doubt the propriety or justice of such conviction or punishment." So it's not just in slavery cases that he's talking about this, or people who aided fugitive slaves, but in other cases as well. And you can see that here in the death penalty case, where what he's referring to is the government's practice. I don't know if it was called this back then, but the practice is still in use today. It's called death qualification, where if you are being interviewed during jury selection about your thoughts on the death penalty, if you say that under no circumstances would you consider imposing the death penalty on someone if you convicted them of a capital crime, you will not be permitted on the jury. Simply, you've essentially removed yourself right then and there. And what he is saying is that that's not a trial of the country when those people are removed, because it doesn't reflect the full spectrum of feelings and opinions and whatnot. That's a trial by the government. Robert?
Well said. One thing that I I'm struck in your remarks a little while ago was the thought, or what many individuals may bring up to you about well, you should only nullify if it's unconstitutional. Now it may be unjust, but it's not unconstitutional, so it must stand. And what a sad reflection if that's something that you feel you must uphold, a constitution that would not be committed to justice, a way of life that, or an institution that disregards justice, where it's like we're in a court of justice. We are in a society for whom most of us feel that justice is one of the highest, dearest values that we can have as a society. So what a strange notion that justice would not be what you would use as your guiding light, but whether it is constitutional or not. And I sort of, a lot of what was said, and the distinction, of course, between government and country and these other notions, but I got me thinking of the line from Cool Hand Luke, where the guard kind of uses his defense. Well, hey, it's just my job, and Cool Hand Luke responds, just because it's your job, don't make it right. And I think Lysander Spooner definitely paves the way and says, heck yeah, it's your job is to do the right, regardless. It's not that is your job. It is not to uphold the Constitution. You're in a court of law, natural law being the highest law, and adherence to that means that you must comport with a just outcome.
So another era in which just outcomes were kind of in question, including, and again, I think this also supports, well, I guess it wasn't an amendment at the time, but I think again, he still would have agreed with us on this. I suspect we're all in agreement. But another era in which just outcomes were kind of key that Spooner wrote about was with regards to alcohol prohibition laws. Now, he has written an essay called "Vices Are Not Crimes: A Vindication of Moral Liberty." And I thought it read so well, dovetailing with his work during the abolitionist era. I thought it surely must have been written then. To my surprise, this was actually published in 1875. It's just 25 years after illegality of the trial of John W. Webster. So that first speaks to kind of his longstanding interest in justice and producing just outcomes. But where it was published was in a book by someone named Diocletian Lewis. The book was entitled "Prohibition a Failure, or the True Solution of the Temperance Question." The book came from a perspective of someone who was anti-alcohol, but also against alcohol prohibition. Like that was not the way in their mind to solve that. So this, one of the things that I really like about this work is that he defines the difference between vices and crimes. First two sentences: vices are those acts by which a man harms himself or his property. Crimes are those acts by which one man harms the property or person or property of another. Vices are simply the errors that a man makes in his search after his own happiness. Unlike crimes, they imply no malice toward others and no interference with their persons or property. Let me switch back. Any thoughts on what that might have to do with jury rights and Spooner's advocacy of people voting their conscience?
Well, one thing that this is a bit of a side note, and I don't know as much of the details, maybe both of you know, but as far as I know, you've got so many people who are concerned about individual rights in so many great ways. Two names of which I'll bring up would be Frederick Douglass and Susan B. Anthony, who became part of the temperance movement. Now, I don't know to the degree of their participation. I mean, certainly one could just be opposed to people drinking and say, working through persuasion, saying, hey guys, this is not a good idea. If you want to advance, if you want to protect your rights, if you want to have a healthy, fruitful life, you should be, you should abstain. But most of these temperance movements had a legal component that were trying to create, legal boundaries, legal restrictions from engaging in drinking. And so, and again, I don't want to indict Douglas or Anthony at this moment, because all I know is they were involved in the temperance movement, but I don't know to what extent or to what effect they desired. And maybe you guys could help enlighten me. But I just think this is, again, what we were talking about earlier, the amazing principled nature and consistent nature of Spooner, where he takes it from start to finish, where some of these people, they might have achieved their goal and said, okay, I've got a vision for how, and this is so many people, right, that we talk to in our daily lives, and probably us to a certain extent. It's hard to maintain consistent principles all the way from A to Z. And you say, okay, we achieved this goal, and that's part of my vision of how the world should be. What are other things that I want the world to be? And it's like, well, you start diverting from maybe justice or natural law and going towards just the utopia that you have a desire for. And it really kind of separates those who have thought about this in maybe a kind of in a consistent fashion, where you just view liberty as being the primary, as opposed to the world that I want as being the goal.
I will say, in defense of the ladies, one thing to keep in mind is that women didn't have liberty at this time. So certainly not on an equal basis with men. And so while I definitely disagree with how the temperance movement veered towards making laws about things, you can kind of see when you don't have options for yourself, you can kind of see how that becomes the natural way that you think of to deal with things. There's a notable figure in Prohibition history named Carrie Nation. She spelled her first name Carry, and her name became a sentence, her middle initial being A, so Carrie A. Nation, who is widely despised in Montana because she would go around to bars and other establishments and scream at them to, be better, be more biblically appropriate and close down and stop serving alcohol. And if they wouldn't, she would just start whacking up the place with a hatchet. And so obviously I think, what a terrible person. I get her biography, and then I find out, well, come to it turns out she was married to a man who was drunk, spent all their money, abused people. She ended up having a terrible time getting, out from under that situation. And when she did, she was actually a very kind person who spent her life setting up shelters for women in similar circumstances. So, well, yeah, that's not a great way to fix it. You can kind of understand someone who hasn't had, I believe it was Jane Schaefer, who I heard at one conference. She was talking about raising children to appreciate liberty. And one of the things she said was, make sure they get a taste of liberty, because once they do, they don't forget it. And I thought, so many of these people in this era, women who are against alcohol and wanted the government to prohibit it, they hadn't really had a taste of liberty. So I will throw that out there in their defense. I'll also note, both Frederick Douglass and Susan B. Anthony's lives overlapped substantially with Spooner's. Susan B. Anthony actually went on a two speaking tours promoting jury nullification in the 1870s. She went and voted along with a few other women at a time when it was said by the government to be illegal for women to vote. That was a point of dispute, but probably most people would, as with most people would probably say, yeah, slavery was unconstitutional, even though Spooner had a legal argument against that. It was kind of similar for her. She had a legal argument against it, but I think most people would say, yeah, it was illegal for women to vote in certain elections. She did so, was arrested, and went to trial over it. But before she went to trial, she went to every town in the county where she was going to be tried and gave a speech advocating for jury nullification for her, the other women who had voted, and the voting officials who had accepted their ballots. And the government was like, oh, crud, how are we going to get a conviction? So they changed the county that she was going to be tried in. So she set off on a second tour. And as it turned out, we never found out what the jurors would have said, because the judge in that case, the whole trial was had. She wasn't really allowed to speak because she was a woman, so she couldn't be a witness. Again, where's the freedom? But she basically, the trial wrapped up, and the judge said to the jurors, it's obvious that she's guilty, so I'll assume that's what you're going to say. I accept your guilty verdict. They never got to say a word. She was convicted and fined $100, which she never paid. But so we never got to find out if those jurors would have nullified or not. That was kind of sad to me.
That's intense. And,
Yeah.
I mean, reflective of a general, set of institutional arrangements that really restricted women's freedom, because it's not just the suffrage stuff, but especially relevant to the alcohol type related questions. Women were quite restricted in their rights, especially if they were married. So, for instance, you had prohibitions on married women owning their own property until the passage in various states of the Married Women's Property Acts, which my colleague at George Mason University's Mercatus Center, Jamie Lemke, has an excellent paper on that might be of interest to some viewers. But in general, there were all these different restrictions on the rights of women, especially married women. And of course, going back to the postal monopoly, we eventually had also restrictions on the ability to communicate about issues such as sexual assault by husbands or marital rape, and as well as contraception, right? Transmitting information about those was criminalized as a violation of obscenity laws, such as the Comstock Act. And so you had simultaneously a set of institutions that restricted women's autonomy, dignity, and rights to freely associate and own property, and efforts to criminalize and restrict and censor political speech regarding it. And so that's really the institutional climate that we're operating within there. And so it's understandable that people who were not allowed to own any property of their own and were bound to a particular person would be very frustrated that this person who had such power over them was getting drunk. At the same time, the relevance, what I think Spooner would argue there, is that the relevant crime, or perhaps also the relevant tort, but in this case, since he's doing vices are not crimes, the relevant crime would be what the husband does to the wife in that context, and potentially also what the state does to her to restrict her options. The consumption of alcohol is not in itself something that can be done with criminal intent, because it is not an action by one party against another. That's really the essence of his argument in Vices Are Not Crimes, that crimes are those acts by which one harms the person or property of another.
Yeah. And it's so interesting. I'm going to have to dig into more Spooner, of course, because just thinking about those first two sentences, vices are those acts by which a man harms himself or his property. Well, when you're defined out of your property by marriage, then any man who's getting drunk and spending all your hard-earned money, on drinking, because now it's his property, no matter how much you worked for it, well, that becomes a vice in that context. Whereas it says crimes are those acts by which one man harms the person or property of another. I think most women who at that time were working to try and keep their kids alive while their husband was off getting sauced would probably say that they were harmed or their property was harmed, but by law it wasn't their property. Mm-hmm. So that's a problem created by the law, not alleviated by it.
And I'm sure we've talked about this in other webinars before, but I still enjoy when I finally realized, I'm sure I was late to the party, of what Chicago was really all about, the Chicago the musical, where these women are being found not guilty of crimes that they seemingly clearly committed, but by all male juries. And the musical, right, that's they've got this seductive nature, they're kind of seducing all these men to find them not guilty. But the reality was that you could find reasonable people who are like, yeah, she doesn't have rights, she cannot leave the conditions under which she is being abused. And so unfortunately sometimes you just have to kill a bastard. You gotta go. That's for some of these people, that was their only option, and they said, okay. I mean, when you're left with no other choices, sometimes that's the only extreme, because the one right they did have, I guess you could argue, was their right to life. They did have some sort of a right to self-defense, at least as determined by those jurors. Now, maybe they couldn't leave with property and things like that, but they weren't saying you had to lay down and be beaten to a pulp or to death. So that to me is a fascinating, again, I want to maybe towards that discussion of Carrie Nation. There's reasons and excuses, right? Like she had understandable reasons for doing what she did. It doesn't excuse it. And maybe, and I don't know, maybe, and I guess in this case, maybe the jurors felt that it did excuse it because there were literally no other options in this circumstance. Somebody has somebody has a gun on you, or threatens you with bodily harm, and they have both the desire, the ability. I mean, this is something that can happen. Then most juries find, hey, you at that point, you have to do what you have to do to survive. So it's fortunate that that even in those cases, in those times, right, where you had all male jurors who, for their own personal incentive, it would seem that they would say, no, guilty. A woman should never kill her husband. God forbid my wife ever, do that, and a jury, be facing me. But they were looking at it and saying, yeah, even as men, where our incentive would be that no husband should be killed, they say, no, this is a condition under which justice would not prevail if we found them guilty.
Yeah, for those who don't know, Chicago the musical is actually based on an era in Chicago during which there was a higher than usual, I guess, amount of spousal murders, with women murdering men. And one of the I actually found a paper. I don't have the link handy, so I can't put it in the comments, but one of the quotes from the time was basically someone was like horrified that women wouldn't be convicted of murder when they were killing husbands who had been habitually abusive to them. This would be not in the moment where you're defending yourself against them, but like waiting until you have the opportunity and then doing it. So it's not considered self-defense, it's considered murder, because you premeditated it and planned it out and everything and did that. But the quote was along the lines that, well, if we let women murder every man who's going to hit them, well, every man in Chicago will be dead. It's like, we can't have that. I'm not sure why the alternative didn't occur to this person, that perhaps men should not be beating women, but that was another time. So, but yeah, so there were actually a higher than usual number of trials for that, and large number of acquittals. That was a historical thing upon which that musical was based. All right, it looks like we just have about 7 minutes left. I do want to let folks on Facebook who are watching live know that I have posted in the comments links to Vices Are Not Crimes and Illegality of the Trial of John W. Webster, which we have on our website. Still working on getting an essay on trial by jury up on our website, but you should be able to find that easily by Googling, if you like, or using whatever browser of your choice. And I will work on getting more of that up as time and resources permit. Is there anything anyone would like to comment on that we haven't talked about, anything that stands out in the works we were talking about or other works, or any final thoughts from anyone?
I'll just bring up, this is not these should not be the closing remarks. These are kind of little sidelines on Lysander
Okay.
Spooner that I like. But I'm not sure if I'm saying the name of this town right, Athol, Massachusetts, or Athol, where he was born. Randy Barnett had commissioned a little plaque to be put up in front of the house. So it is kind of a cool thing. If you're in Western Massachusetts, it's right on the border of that and New Hampshire. I've driven to it. I've stood there and taken pictures. There are people who actually occupy the house, so just be respectful of them. They'll look at you like, what are you doing? Because, probably very few people are interested in Spooner, but I was, and I was all excited to see this. I know that I'll try to get you a link, Kirsten, to it. I feel like I might have given it to you once before. There is an anarchist walking tour of Massachusetts and of Boston, and I believe that there is in that guide there are spots that are related to Lysander Spooner. I know like Benjamin Tucker is covered and others, but I'm pretty sure there's things that cover Spooner in that as well. So if you're in the Massachusetts area and want to binge on some Spooner in physical reality, those are some things to look to.
I'm going to also add, for people who are interested in learning more about Spooner, Randy Barnett is an excellent person to search for. Randy Barnett Spooner will get you a lot of results. And I will also recommend, as was recommended to me by Nathan, Helen Knowles, or I now see her. I think I've seen her as Helen Knowles before, but her most recent paper that I've come across, which was from this past summer, has her listed as Helen Knowles Gardner. So that's KNOWLES-GARDNER. Very, very prolific writer on Spooner's legal writing. And for Nathan and Robert, I just posted a link in the chat to the paper from this past summer if you're interested in it. But Randy Barnett and Helen Knowles Gardner are two excellent resources for learning more about Spooner, his legal thought, and its applications and whatnot. So I do want to throw that in there. All right, now with 4 minutes to go, any final thoughts, since those were just side notes?
Well, I mean,
I think
oh, sorry.
Go ahead. No, you.
All right. So I think really what's core to Spooner is that we're seeing a person throughout his life trying to figure out, elucidate, and act upon principles of natural law, natural rights, and individual liberty. And we've talked about stuff from throughout his career, and so we see how he applied that quite consistently and persistently in different historical contexts, right? So he applied that in the era of slavery to become a staunch advocate for abolition. And that included everything from arguing that slavery was unconstitutional to supporting efforts to aid and abet slave revolts in his letter to the non-slave holders of the South, which I believe was posted in 1858, as well as his work on trial by jury, where he said, look, for any unjust law, people should be able, or unjust application of the law for that matter, jurors should be able to act on their conscience and serve as a check on the power of government. And so then we see after that era him extending these same principles to things like alcohol prohibition and offering us such a clear argument about the distinction between vices and crimes that it has very clear applications to any other attempt to criminalize activity that is voluntary and consensual rather than an act of one person to harm the person or property of another. And so that's really, I think, the core lesson from Spooner is that you should try to think through very clearly the implications of your principles. And as you figure out what your principles imply, you should act courageously and consistently to try to build a world and support the efforts of others to protect liberty and justice for all. So that's really what I see as the lesson of Spooner's life.
Nathan, that is so wonderfully said, and that has so many great implications for practical use in jury situations today that I have just been inspired to go get the link for, and I will be sharing here in the comments shortly, a link to our guide to jury duty. So don't just read the two essays that I posted links to, and don't just check out trial by jury, but also understand that these are practical things that you can use in your daily life. And just as Nathan was talking about, there's a thought process to it. And I'll add to what Nathan said. It also includes being a little bit smart about how you do some of these things, because, of course, the government is busy trying to get rid of people who represent views they don't want. So we cover some of that in our guide to jury duty. Robert, any closing comments from you?
Well, beautiful words already. I guess I would the only thing I can think to add would be to think about things, just kind of an activity for our listeners, maybe to kind of engage in Spooner's thought process of the government versus the country. And of course, that's not just for trials, but just these notions of government powers and liberties of the people. And think about where it is you fall, and maybe you can think of it as a spectrum as opposed to a 1 or a 0. But think about maybe your thoughts and your positions and where they fall on that spectrum, and what is the healthiest perspective, because again, we kind of have biases. We all have our visions of what a perfect world looks like. But as some of what we've talked about, sometimes we have different views of what that is from what other people hold as well. And so what is the framework by which the most amount of human lives can flourish, that we can allow for as many opportunities and liberties? And does that fall with a trust in government and its power, or with people and their liberty? And I think Spooner did a great job of considering in that way. And so I kind of put that forth as a challenge to our listeners to do the same when thinking about social issues.
Well, that is a wonderful way to wrap up. Both your comments are just so beautiful. Thank you so much for joining us today, Nathan and Robert. Thank you to all who have joined us live for the live stream on Facebook, and to those who will see this later when I get the recording posted, hopefully in a more timely manner than I have in the past. But I'm hoping to make this an annual event. And hopefully next year we'll do a better job of inviting guests. My fault for not getting on it sooner, but I've had some personal life issues that have kind of overcome events lately. But hopefully next year we'll have some other new voices, as we did last year, because there's so much to delve into and so many different ways to look at things. For the first time today, I really thought about this vices are not crimes, in relation to, well, what happens when it's legally defined as your property, but in reality, that you're taking from someone else. So it was really good to talk to you both. Thank you so much for joining me. Thank you so much for, go ahead.
And don't forget to support FIJA and its mission.
Which you can do by going to fija.org/give if you like. It's still last year's campaign page up, because again, personal life issues have been rough lately, but I will get that updated. In the meantime, you can just give on the 2023 page. It's fine. You will get a receipt automatically with the actual date of your contribution. All right. With that, I'm going to go ahead and stop the live stream to Facebook. And if you guys want to hang around for a minute, we'll do a quick after briefing. Thank you so much, everyone. Happy birthday to Lysander Spooner, and have a wonderful day and a great weekend.